Hi everyone, this is Mallory Flowers on behalf of Jennifer Shelton and Associates. We are coming to you live from Washington, D.C., and welcome to our Webinar Wednesday series. Thank you for joining us. Our webinars are held every Wednesday in 2018 at 12 p.m. Eastern Time, and our speakers range from accountants to attorneys and other industry professionals. The full schedule for the rest of the year is on our website underneath the webinar tab. In the interest of time, we do not take questions. Our speaker's contact info is posted on the last slide, so if you have any questions, please contact the speaker directly. And the recordings are on our website underneath the Archives Webinar tab, as well as on our YouTube channel. And this is just a quick blurb about us. Jennifer Shelton Associates is based in downtown Washington, D.C., and we help both product and service companies with federal contracting. Our clients are domestic and foreign, defense contractors and civilians, and our services range from market analysis reports to contract vehicles, including the GSA schedule. We can also help you with proposal writing and post-award contract administration. More information about our services and upcoming events can be found on our website. All right, so we're going to go ahead and dig into today's presentation, which is compliantly involving non-U.S. persons in your federal government contracting business. And Margaret Cassidy is our speaker today, and you can learn more about her background on this slide. All right, Margaret, thank you for joining us, and I'm going to go ahead and hand the floor over to you.
Thank you so much, Mallory. As Mallory said, my name is Margaret Cassidy, and I advise businesses large and small on working compliantly with the United States federal government, as well as foreign governments and state and local governments. And one of the issues as a federal government contractor, if we go to the next slide, please, Mallory, is how a U.S. federal government contractor, particularly ones that deal with the defense or law enforcement or intelligence community or any of the other organizations or agencies of the United States government that may have sensitive information from a national security or military or law enforcement perspective, on how they can employ and also partner, team, or otherwise have a business relationship with a non-U.S. entity. So I'm basically going to come at this in two ways. I'm going to come at it from the angle of can a non-U.S. entity have ownership, interest, control, or otherwise work with a U.S. federal government contractor? And the answer to that is yes. Then I'm going to talk about employing non-U.S. persons when you're a federal government contractor. So going back to the issue of can a non-U.S. entity or person have ownership, interest, or control over a U.S. federal government contractor? The answer is yes, but it is really dependent on whether that contractor performs or seeks to perform classified contracts. Mallory, if we can go to the next slide. If contractors, U.S. defense contractors, or any contractor, is seeking a facility clearance. A facility clearance is when the United States government says, we have cleared this entity to be able to do sensitive defense work, sensitive intelligence community work, sensitive law enforcement work. And this can occur, of course, in the defense and intelligence agencies, Department of Defense, Central Intelligence Agency, Defense Intelligence Agency. But please remember that some government agencies like the Department of Energy and a few others that don't seem to have access to intelligence, military, or law enforcement information may in fact have it. So if you're a contractor and you want to perform certain services for agencies that have access or will give you contracts related to classified materials, then you need to seek a facility clearance. And that is the facility where you're going to perform your services, and the rest of your organization is going to have to engage in certain regulatorily required behaviors, both operational and business development, to make sure that the U.S. government feels comfortable giving classified information to you. In doing so, you, as a contractor, you have to demonstrate to the government that you have no foreign control or influence over the contractor. And this foreign control or influence doesn't mean that you have absolutely no foreign involvement in your entity, but rather that the foreign involvement neither exposes classified information to a non-U.S. person and a person who does not have a clearance, and it doesn't jeopardize performance of a classified contract. That's if you're seeking to do work around intelligence and classified materials. If you already have a facility clearance, then you have an ongoing duty to notify DSS, that's the regulatory agency that gives clearances, about any changes in potential foreign ownership, control, or interest. So basically, whether you seek to get a clearance for your facility or whether you already have one, you need to work hand in hand with the government, advising them on whether or not you have foreign involvement at all in your business operations. And if you do, what sort of controls can you put into place to make sure that they're not either going to get exposure to classified information or that they're not going to do something that may jeopardize classified contracts. If we move to the next slide, I have some more information on what foreign ownership, control, or interest means. You need to think about this in the most broadest of terms. It just doesn't mean ownership, as you can see by the very definition. It means having any sort of interest. So under the definitions, the legal definition, this review by the federal government to see if there's foreign interest in your business covers the following. Does a non-U.S. person or non-U.S. entity have the power to direct or decide matters of your business relating to either management or to operations? This includes, of course, delivering on contracts. And is that management over is that ability to control management or operations done in such a way that the non-U.S. entity or the non-U.S. person may have exposure to classified information or adversely impact the performance of classified contracts? So for example, think to yourself, if you have a line of credit from a non-U.S. bank and you're either seeking a clearance or you're already a cleared facility, if that line of credit from a non-U.S. bank would jeopardize how you perform that contract because it may not give you the cash flow you need to continue to perform that contract, then you're going to be in a situation where the government may not give you your clearance requirements. Oftentimes people think of foreign ownership, control, or interest from somebody actually owning your company or investing in your company, but don't forget it also includes other agreements or loans or contracts you may have in place. The other question or the other issue that people often forget is it doesn't matter if the foreign person or entity actually makes decision relative to your operation or whether it does anything to control your operations or your management. They maybe are a silent partner. It doesn't matter. It doesn't matter if they use their authority or not. As long as you have a silent or passive investor in who is non-U.S. person, you still are going to have a disclosure obligation. So here are some examples. This could be owners of your business. It could be shareholders. It could be lenders like we just talked about. It could be some non-U.S. entity that you affiliate with. It could be your subsidiaries. It could be directors who are the directors of your organizations, your executive team members. It can also be key personnel. You can have a significant contract with a non-U.S. entity to deliver your IT services. If you're a cleared contractor and that IT contract with a non-U.S. entity is significant enough, or even if it's not very significant, if it has the ability to shut down your day-to-day IT operations, then you're in a situation where the government may not continue to approve you as a cleared contractor. It also, of course, covers joint ventures and teaming agreements. If we go on to the next slide. So just because you have some sort of foreign person or a foreign entity investing in your business, being a manager of your business, being an executive of your business, lending you money, providing you IT services, any of those types of things, it does not necessarily mean that you use your clearance. Rather, you need to somehow manage that foreign ownership, control, or interest. If it's ownership, for example, you have investors, shareholders, investors, whether passive or active, members of the board of directors, executive team. If you have that type of leadership or investment from a non-U.S. person and you're a cleared contractor or you want to be, you need to have policies and procedures in place to keep those non-U.S. persons walled off from your classified contracts, but they also need to be, for the most part, walled off from managing classified contracts. This gets into, are they overseeing the financials of that classified contractor? Are they making employment decisions for your employees who are performing on that classified contract? And depending on what those employment decisions may be or those financial decisions may be, you may have a situation where the government decides, the U.S. government says, listen, you're not keeping foreign persons out of the business of your classified contracts, and you may lose your clearance. However, you could set up policies and procedures so that your non-U.S. leaders are not getting involved into the organization and management of your contracts or getting access to classified information. Another area that's important to manage is shared services. If you're sharing if you are a U.S. defense contractor and you're the subsidiary of a non-U.S. entity, or you're a U.S. defense contractor and you have affiliations or other relationships, a joint venture or something of that nature with a non-U.S. enterprise, such that you're actually going to share services with one another. Or alternatively, even if you're a U.S. business and you have your defense contracting portion of your new U.S. business, and then you have a commercial part of your business, but in that commercial part of your U.S. business, there's some foreign ownership, foreign control, foreign executives, and you're sharing services between the two different subsidiaries, you need to, again, develop policies and procedures to avoid exposure to classified contracts. Same as in the line above. You need to make sure that the shared services you're sharing, whether HR, IT, finance, are not allowing non-U.S. persons to either have access to classified information or, again, manage the classified contracts, whether day-to-day management or from an operational perspective. Again, think about if your finance team is non-U.S. based and they have the ability to stop the cash flow to perform on U.S. contracts, then you may have a situation where the U.S. government does not appreciate what you have going on. We talked about contracts, loans, and agreements. If you have contracts with, again, I'll use the IT service provider, and it's a non-IT service provider, or you're using cloud-based services overseas, you have to put in controls to make sure that they absolutely have no way to access your classified information, which may require you to set up on U.S.-based IT services. They also can't have the ability to impact performance on your contract, again, by drying up your line of cash or something of that nature. And this covers your contracts, your loans, or agreements, even if unrelated to the performance of your classified contract. Similarly, if you are going to enter teaming agreements or you're going to enter joint ventures with other companies to pursue government work or even to pursue non-government work, just commercial work, if those entities, again, have the ability or access or an interest in your operations, you need to set up policies and procedures to keep them walled off from your classified contracts and from managing your classified contracts and your classified business operations. If we could go on to the next slide, Jennifer. So that's an overview on how you need to segment as an organization to make sure that non-U.S. entities or non-U.S. persons don't have any influence over what you have going on from a classified contract perspective. The next question is, can government contractors hire non-U.S. citizens to work on government contracts? Again, the answer to that is yes. It just depends on whether you have export-controlled information or materials. I put a little note in there. I'm not going to address immigration at all through this discussion. I'm not an immigration lawyer. So if there are immigration issues, which there would be if you're using non-U.S. citizens here in the U.S., then you need to speak to an immigration lawyer about that. What I'm going to talk about is from the government contracting perspective. So if we can go on to the next slide. If you are a government contractor and you have military or defense items, materials, information, software, training packages for law enforcement, anything of that nature, chances are you have to register under the International Traffic in Arms regulatory requirements. And again, this includes if you're manufacturing, designing, engineering, developing anything related to military or defense. If you're exporting defense articles, again, any materials or information, And this, remember, this includes electronic information. It also includes software, etc. If you're furnishing defense services to foreign persons, an example of this is if you're going overseas and you're training law enforcement professionals in Israel or professionals in Italy or someplace, anything having to do with training overseas of the military or the defense, you have an obligation under ITAR to register. Then there's the brokering of defense materials or information or services. If you're trying to set up arrangements between different entities to purchase or sell or buy defense items, then you also have to register. And oftentimes people don't think that they fall under this because they don't think of themselves as a defense contractor. I have a client, he is an investment banker, deal guy. He sets up international deals. He never viewed himself as a broker of defense articles or defense services, but in fact he was, because what he was doing was setting up deals with US defense-based contractors to introduce them and to ultimately sell their materials overseas to a whole bunch of non-US defense contractors. His US defense contractor client was doing what they were supposed to do from an export and regulations perspective. My investment banker client was not, though, because he didn't consider himself a broker for what he was doing. So sort of think a little broadly when you decide whether or not you're actually working in the military or defense environment. If you are working in the military and defense, either with products or materials or software or training or any other services, then you have to register and you need a license. You also have to remember that you ultimately must control where your product ends up. If we can go to the next slide. The other regulation that you have to consider is the export administration regulations. These are commercial products, commercial software, commercial information, commercial training, commercial services that may have a military or law enforcement purpose. It's not their only purpose. They may have one. In this realm, you need to register and get a license if you're selling the item to certain countries or depending on the nature of that item. Again, you cannot export to a non-US person without a license if in fact your product is a licensed product. I have the final bullet, you must control where your product ends up. This means if you do have a license to sell a particular item into Italy and that Italian company is supposed to keep that item and is supposed to use it for their own purposes, if they turn around and sell that licensed item to somebody in Russia or China, Syria, someplace it shouldn't go, you as the U.S. enterprise are responsible for that. As a defense contractor, or even if you're not a defense contractor, as a federal government contractor, in addition to applying these regulations on all of your products wherever you sell them, if you're a federal government contractor, most of the time your FAR flow downs and your FAR requirements are saying that you are in fact complying with these regulations. The way it impacts you as a federal government contractor with employees who may not be U.S. citizens is that having those non-U.S. citizens working for your company and having access to this export controlled information it does actually result in being considered an export. So if we move on to the next slide. The requirements around this, if you have a non-U.S. person, even if they're here in the United States, working for you as a federal government contractor and you have ITAR materials or export controlled materials, you have to remember that you cannot, quote unquote, export to that non-U.S. person, whether that U.S. person is here in the U.S., working for you here in the U.S., or outside of the U.S. working for you. Export means giving in any way imaginable or providing in any way imaginable or even giving access in any way imaginable export controlled materials. You could do it orally by explaining it to somebody. That's considered an export. You could do it in writing. You can do it over email. Or you can do it by just having ITAR controlled materials on your internet system. If non-U.S. persons are able to access that ITAR controlled information, so for example, your non-U.S. employees are able to somehow access your ITAR controlled information that sits on your computers, your IT systems, you have just exported to that individual. So you need to limit and control access of your non-US employees to certain government contracts and to certain of your products, services, information, software if it's export controlled. So what you need to consider doing is you need to wall those non-US persons off from IT access, from certain conversations, from physical access to export controlled materials. And remember, even accidental disclosures are a violation of the export control laws. If we can move to the next slide. That's the summary. That's the end of my presentation. So to summarize, there's two ways to think about involvement of non-US persons. That is in owning and controlling or managing or leading your company. If that's the case and you're a classified contractor, you need to make sure that you have policies, procedures, walls in place to make sure that those persons can't manage or control or get access to classified information. Similarly, if you have non-US citizens working for you and you're a federal government contractor, you need to carefully read your federal government contract, prime or sub, to see whether non-US persons are allowed to be performing on that contract. If they are, then you need to make sure that they are only accessing information that they're allowed to access. If you are a provider of military, defense, or intelligence products or services or software or trainings, then you need to make sure that you have rigorous controls in place that your non-US citizens don't have access to those ITAR-controlled items. To a lesser degree, you have to make sure you have the same controls in place for your export-controlled items. Mallory, that's it. That's my summary. Thanks for the time, everyone.
Yeah, thank you so much, Margaret. And that was a lot of great information. And thank you for sharing your time with us today, and thank you for everyone who joined us. If you have any questions for Margaret, please contact her directly with the information you see on your screen. Next week at noon, we are covering best practices for GSA proposals, professional services, and at 12:30, we are covering DCAA audits. And this concludes our webinar. Thank you, everybody.